Hey everybody, before we start this podcast, I wanted to let you know that this episode of Tabletop Apple is brought to you by D&D Beyond, the official digital toolset and game companion for Dungeons & Dragons. You can use D&D Beyond to build characters, track campaigns, build encounters now, run adventures, and do so much more. D&D Beyond has lots of awesome content for free. I'm talking about the basic rules and articles by writers like James J. Hake and videos from Todd Kenrick. Also awesome stuff from DC, Ashley Warren, so many great things are popping up there all the time for free. Plus, if you're a game designer or a DM or a player, D&D Beyond makes your life so much easier. I have introduced this game to many people over the years, and nothing has made it easier than D&D Beyond. You give people a tablet, they can build their character right there. They need a spell, boom, it's right there. They need an ability, boom, it's right there. It's all defined, all the math's done for them. It just makes playing so much easier, and it makes it easy to get new people into the game. So go check it out at dndbeyond.com. This is Tabletop Babble. I'm James Introcaso. Today on the show, I am super excited because we are talking to a lawyer, an intellectual property and business lawyer whose name is David. David is going to blow our minds and answer all of our legal questions about working with products in role-playing games that belong to somebody else, but we don't know, and there's an open gaming license, but there's also this SRD, and how does this whole thing work? Anyway, it is really cool. David is also a DM and a long-time D&D fan, so we are going to get into it. Here's my interview with him. Okay, everybody. So now I am excited for this conversation. It's been in the works for a while. We have someone who is going to show us a different side of the gaming industry. One I see people talking about all the time. I like to talk about all the time, but someone who truly understands it and can help explain it to us. David, for people who don't know, who are you and what do you do in the world of tabletop role-playing games?
Well, thanks, James. I'm an attorney in San Diego, California. My practice focuses on business law and intellectual property. And I work with some people in the gaming industry, as well as people in media in general, entertainment, entrepreneurs, people doing creative, interesting work. I try to give people the guidance that they need to stay out of trouble. And I'm a Dungeons and Dragons player myself, so that's kind of my connection to the industry.
That's awesome. Yeah, and I can't wait to dive into sort of the legal end of all of this stuff with you. But first, I want to know about your D&D background. So take me back. When did you first lay hands on a role-playing game? What was it like? Were you a player? Were you a dungeon master? How did it go down?
Yeah, it was probably the summer between 4th and 5th grade, and which would have been in maybe 1986 or 7 or something like that. And I was camping. I was in a tent with a couple of friends, one of whom I'm still close friends with. And one of the guys said, "Do you want to play Dungeons and Dragons?" And we had, not only do we have no dice, no figures, we didn't have a pencil, we didn't have anything except for, I don't even think we could see each other. It was like nighttime. So we had voice and imagination. We said, "Sure, I don't know what that is, but we're here, so let's do something." And he kind of led us on some kind of adventure, which I don't remember the details of, other than to say that it was a blast. And I quickly learned that you could play this with dice and so forth. And and I got really into it and played it a lot in various other games, a lot for a while, and then got out of it for some number of decades, and recently got back into it a few years ago, teaching my wife's nephews how to play. And then my wife and I started playing with some friends, and I've sort of mostly always been the dungeon master or GM. That's so it's fun to kind of get back into.
That's just incredible that you had like a pure role-playing game improv experience as your first thing, right? Like there were no stats, there were no dice.
There was no rules lawyering. Yeah, no rules lawyering. It was as theater of the mind as you could possibly get.
Wow. I love that. I love that so much. That's great. And now you are a rules lawyer, I guess. Not a rules lawyer, but a real lawyer. So how did you get into this professionally? Like how did you decide that working with games and artists and creators and working with intellectual property was something that you wanted to do?
Yeah, well, I was always involved in different creative type things. Before I went to law school, I went to cinema school at USC. And while I was doing that, I was also playing music and doing a whole bunch of other things. So I always wanted to do something creative. I went into law school because I didn't really exactly know what to do after college, which is probably about 90% of the people who go to law school will, if they're being candid, will tell you that's how they got into law school. But yeah, I quickly found intellectual property, which we can talk about, in detail. But yeah, I quickly kind of glommed onto that as something that was connected to the creative arts and to media and creative expression in general, and it just kind of all sort of fit together there. Like, I can work with people who are doing really interesting things. I can solve problems for them. I can advocate for them, and I've been sort of doing it ever since. This is going on. I guess I've been practicing for 17 years. So yeah, time flies.
Excellent. So let's define our terms a little bit here. We're talking about intellectual property, and we hear it a lot these days, especially with giant franchises like Marvel and Star Wars and everything else that belongs to Disney. What is intellectual property?
Well, intellectual property is sort of the products of your mind. It's anything that is created that is not, sort of in the real world, at least not at first, but just comes from somebody's imagination. So typically, we divide intellectual property into several different categories from a legal standpoint. So the ones that are most relevant to gamers and game designers would be primarily copyright, which is copyright goes back to the U.S. Constitution, and it's a protection for works of creative expression. So ideas are not copyrightable or protectable under copyright, but the actual expression of those ideas is. So copyright could apply to a drawing or any kind of work of visual art. It could apply to music, or it could apply to anything that's written, from a poem or a short story to a player's handbook or anything in between. And that's that's kind of the first thing that comes up. And the second piece that's relevant to this world is typically trademarks. And trademarks are a legal protection that is granted to anything that identifies you or your business as the source of goods or services. So a brand name, a business name, a logo, a slogan, a lot of other things can be trademarks, but those are kind of the most common elements that are protectable as trademarks.
Okay, so when we're thinking about these things, specifically with relation to games, I see a lot of times people don't understand necessarily what they're getting into or how they're getting into something, and they'll maybe publish on a platform that they don't realize, the rights they're giving away. I'm thinking specifically of the Dungeon Masters Guild in this case, that people will come there and not realize, this is what I get back for this, or this is what I'm giving up to do this. There are different platforms that are right for different things. How do we get to understand that, and how do we get to know that? So like if we wanted to create a Dungeons and Dragons product, how do we know what is the IP of Dungeons and Dragons, and what are things that are okay to use?
That's a good question, and I'll try to kind of clarify it as much as possible with the with the caveat that it can be a little complex. D&D and Wizards of the Coast have created what's called the Open Gaming License, or OGL. So they have essentially opened up part of the game to allow people to independently create within the context of the game. And so, just to keep it simple, we'll talk about D&D, although, some of these things could apply to almost any other game. So that doesn't mean that Wizards has lost any of their legal rights. It just means that they are saying, hey, we're going to allow people, independent creators, to create things and sell them within a certain context. There are some things where they're not going to really bother you if you create things and just sell them on your own anywhere online or whatever you want to do. And those are kind of things that fall into the OGL. typically that would be things that are not necessarily specific creations of the Wizards of the Coast or TSR or Dungeons and Dragons. The things that are more closely protected and closely held are the sort of brand names that are more closely associated with them and that they actually developed internally. So like something like the Beholder is a very common, everybody who plays knows what the Beholder is. That's something that was created by the Dungeons and Dragons team. It didn't exist before that. So something like a dragon obviously goes back, thousands of years. Nobody owns the concept of a dragon. But the Beholder or, the Forgotten Realms, so names of places, names of specific characters, and names of certain kind of creatures or other elements in the game that are specific to Dungeons and Dragons, those they will only let you use within a certain limited context. And in this case, it's the Dungeon Masters Guild. So you can play with those tools. You can make up stories and adventures and resources that use those assets that Dungeons and Dragons clearly, or Wizards of the Coast clearly owns, but only in the context of this one channel where there is a certain profit split and there are a lot of specific rules about how to do that. But that said, I just want to make it clear. So the way that copyright works is that as soon as you create something, and I'm going to use the actual legal language here, as soon as it is fixed in a tangible medium of expression, meaning it's fixed somewhere in the world, which could be on paper or it could be on a computer, anywhere where somebody else could encounter it and read it or experience it. As soon as you create it, at that moment of creation, you own the copyright. So you don't have to file anything, you don't have to do anything, you don't have to mail anything to yourself or any nonsense like that. You are the copyright owner immediately at that moment of creation. So what that means is that if you, let's say, write an adventure and you're intending to put it on the DM's Guild and you're using, let's say Forgotten Realms, so you're using those place names and, the Sword Coast or whatever the case may be. And then there's other elements within that adventure that you have created yourself. So maybe the names of characters that you've created yourself, or names of places or creatures that are completely unique to you. You're the first person to come up with it. You're the first person to name it this and create it. You still own those individual assets. And neither Wizards of the Coast or any other creator, whether it's in DM's Guild or elsewhere, has the right to use those without your permission. So just because you're playing in this specific sandbox that Wizards of the Coast has created and licensed to, and there are certain restrictions about it, doesn't mean that you have no intellectual property rights.
So you still own something when you create it, when you are the original creator of that thing, right? And I'm glad to hear you say you don't need to mail it to yourself or register it with the Writers Guild of America, say, or that kind of thing. Does doing those things increase your chances in litigation if things were to go there?
Yeah. So the number one, mailing something to yourself is nonsense. Anybody who tells you that mailing something to yourself will give you any legal rights, that's a person whose legal advice you should not take. That's number one. Okay, easy to dispense with that one. Number two, you don't have to file or register anything with the Writers Guild of America. That might be for screenplays, but even in those cases, typically it's not required. Now, in terms of the actual filing to register a copyright, if you've created something, so let's say it's a role-playing game adventure, and you want to protect it, you're concerned that others may rip it off, or you want to sell it, and leverage it, and maybe use those characters or those elements in further adventures or in some other context, like a book or a movie or whatever. It's definitely advisable to register that with the United States Copyright Office because our friends in the Supreme Court recently made it very clear in a case this year that you cannot file a lawsuit against somebody who has infringed on your copyright, so just stolen all or some of your copyrighted material, unless you have a registration from the United States Copyright Office. So the good news about that is that it's pretty easy and relatively inexpensive to do so. Copyright.gov is the U.S. Copyright Office website, and in this kind of context, I'm just talking about the U.S. A lot of these things will apply outside of the U.S., but I'm a U.S.-based lawyer. So for your listeners who are outside the U.S., consult local counsel. But as far as the U.S. goes, you can go ahead and register a work. So if it was an adventure that you wrote, it would be considered a literary work. With the U.S. Copyright Office, it's pretty self-explanatory. I mean, if you can understand the rules of, Dungeons and Dragons, you can certainly navigate your way through the U.S. Copyright Office website. It's pretty, do-it-yourself oriented. And the filing and registration is pretty simple and relatively inexpensive. I don't remember exactly what it is right now because I actually don't do it very much because it's do-it-yourself, so most of my clients do it for themselves. But I think it's like $45 for a registration. There's a few different fees. So, if you have created something that has some monetary value and you want to, leverage and exploit it, and you're concerned that you may at some point need to enforce those rights, go ahead and file and get that registration done. Because, in the context of these things, it's not a huge investment and it's not going to take a lot of your time. Once you learn how to do it once, you'll be easily able to do it again. And so that is one situation where, even though technically you own the copyright immediately upon creation, you can't necessarily legally enforce it until you actually go through that step of filing and registering.
So what do you wish more people knew about IP? We're already dispelling some rumors that I've heard multiple times. I've heard that thing about mailing to yourself a bunch. I even saw it on an episode of Monk a long time ago. So, and television's never wrong. So what are some other things that you wish people knew?
Yeah, I guess the first thing that comes to mind is, the difference between copyright and trademark, which is kind of where I started with this. We talked a little bit about copyright, but we can talk about trademarks as well because they're an important piece of this. And everybody gets it wrong. I think it was maybe 2 weeks ago I was reading an article in the New York Times about a copyright case, and they referred to it as a trademark. If you think the role-playing game Twitter community is picky and gets into things, you should see what the intellectual property lawyer Twitter sees that some major media has gotten this wrong. Everybody closes their staff. So we're just as geeky as any other group. In fact, this weekend I was at a intellectual property lawyer convention in Las Vegas, and I was having conversations with different people about the fact that I was going to be on this podcast, and they were very excited and jealous. So,
oh wow!
If you're looking for the geekiest group of lawyers, intellectual property is definitely the way to go. That said, okay, so copyright and trademark, people really get them confused. People will also say patent, which is a totally different thing. It's understandable if you're not an expert in this area to get confused, but I want to make sure your listeners understand the difference. So again, a trademark applies to anything that's what we call a source identifier. So it could be a business name or brand name, but the name of a character could potentially be trademark protectable. Any kind of unique element that you've created that is consistent across different products and that people can recognize as coming from you or your company can function as a trademark. And while the Copyright Office and the copyright process is very relatively simple and do-it-yourself and inexpensive, the trademark side is the opposite of that. It's a very complex, time-consuming cost. It's not as inexpensive, and it's really the type of thing where some people can do it themselves and be successful, but that's the area where you want to really look at finding an attorney to assist with the process. Because I've been doing it for like 17 years on a daily basis, and I learn some new trick or nuance or issue every single day. And so where would trademark come into place? For a designer or creator. Well, it could be the name of your company. That's very commonly something that you want to look at as protecting as a trademark. And you also want to make sure with all these things that you're looking at it from both sides. Meaning, not only can I protect this and prevent somebody else from using it, but also am I infringing on somebody else's rights by using this name? So let's say you are launching, you're starting your own game company, and you're going to go on Kickstarter or Patreon or whatever, and start ramping up from there. Well, you want to make sure that nobody else has a name that's identical or similar. Otherwise, you might get a cease and desist letter because they may see that you are infringing on their trademark rights. So you got to do your due diligence, make sure that that you're covered in that area, and of course, you can speak to a lawyer about the right process to do that if you're not sure. And then once you have established it, you're said, okay, this is good. This is the name I'm going with. You're going to want to look at whether it makes sense for you to file to register that as a trademark with the United States Patent and Trademark Office to protect those rights so that should somebody else come along and start selling products that are identical or similar, using similar branding to you, that you can effectively prevent them from doing that. So again, it might be the name of your company, and then as you're going along, okay, I've created a game, let's say. Well, that definitely would be something that you need to look at trademark protection. Or, if you have characters or other elements like that that are really unique, distinctive, and are starting to get some level of popularity in the industry among fans, collectors, and so forth. Again, that's something where at least worth looking to see if it's it's appropriate to protect those as trademarks. So that's really the first thing that comes to mind is just the confusion between these two related but actually separate areas of intellectual property, and when you need to think about one and when you need to think about the other.
This is great. I had no idea there was a difference between the two. I used to think that if I saw a trademark, a little TM in a document next to something, that it was all replaceable, right? That it could be a copyright symbol, C in a circle or an R in a circle, right? What is that? What is all rights reserved? Is that a different thing too?
Yeah, let's talk about all those symbols because they are important. So the copyright symbol is a C in a circle. You're not required to put the copyright symbol on something that you own the copyright to, but it is recommended because it lets people know that you're claiming copyright in this and that you're the creator. So typically the right way to do that, and again, this is in the U.S. and I should just say that. I should have said this at the outset, but while I am a lawyer, I am not your lawyer, and nothing I say is legal advice and so forth, but just kind of general educational. The right way to do it is copyright, which is C in the circle, and then the year of creation, so it could be 2019, or it could be a series of years if you did this over, let's say 2017 to 2019, and then your name or the name of the company. So it could say, copyright 2019, James Introcaso, and that would be the right way to do it. You don't have to do it on every page. Typically, it'll appear on the first page of a document or on the bottom of the website or something like that. And there's nothing you need to do other than that. You don't need to have a registration to use the copyright symbol. As soon as you create something, immediately you can write that symbol on it, and you're totally fine. The trademark side is a little more complex because there's two different symbols. There's the uppercase TM, which is very similar to the copyright symbol. As soon as you create a brand name, let's say you decided to name your company, you design a logo for it, and you say, okay, this is my name, this is my brand. You can stick that little TM in capital letters next to it. There's nothing stopping you from doing it. You're legally allowed to do that. It just is an informal way of saying, hey, this is not just a generic term. This is actually our brand, and we are going to protect it. However, the R in the circle is the registered copyright symbol. So it's capital letter R in the circle. You can only use that in the United States once you have an actual registration with the United States Trademark Office. So that means that you have filed the application. It's gone through the whole application process, which takes months and months and months, sometimes years, and then they have issued you an actual certificate of registration. That's when you can use the R symbol. So a lot of times, I see this all the time with my clients. They will, they'll come up with a brand name. We'll file a trademark application, so it's been applied. Then they'll have their, graphic designer or marketing company or somebody that they use on Fiverr or whatever, anything in between, create a logo. And then that person who created the logo, just trying to do the right thing, sticks the R in the circle next to it. Well, then you actually are not allowed to use that, and it's going to screw up the trademark filing. So then they have to go back and change it, and it costs them money, and they're upset about it and so forth. So if you're listening to this, you can only use the R in the circle if you have an actual registration from the United States Patent and Trademark Office.
Okay, and I always thought that stood for all rights reserved. I guess that is something my father told me when I was a kid, I feel like, and now I'm realizing it was just a lie.
Well,
probably just made it up.
I'm sure he was doing his best. Yeah, all rights reserved isn't really a thing that we use. So that one, that's kind of older language, but it's just not really too relevant anymore most of the time.
Hey everybody, I just wanted to let you know that this podcast is brought to you by Elderwood Academy. Elderwood Academy are the makers of many fine gaming products, handcrafted wood things like spell boxes, hex dice boxes, all kinds of amazing things that will make your game incredible. So go check it out at elderwoodacademy.com/don't split. My favorite thing is the dice rolling tray that looks like a scroll when it's all rolled up. You can take it with you anywhere. They are beautiful. You can get custom designs on this tray or really any of their products. So amazing. So go check it out at elderwoodacademy.com/don't split. That's elderwoodacademy.com/don't split. Let's get back to the babble. So let's talk about rules. I see people all the time on social media say rules cannot be copywritten, that you can't have a copyright on rules. And so you're allowed to use any sort of mechanical bits of another game that you want to. Is that true? And what defines then, if it is true, rules versus other parts of a role-playing game?
Yeah, that is, I would categorize that as mostly true. Which for the internet that's pretty good.
Yeah, that's good.
So something like if you're trying to attack somebody, you need to roll a 20-sided die, and anything over a 10 is a hit or something. That's a rule that I just made up, and that's really more of an idea or a concept. That can't really be protected under any kind of intellectual property, specifically copyright in this case. So what can be protected is the whole kind of compilation and the way that they're expressed. So just because I say an individual rule like that cannot be protected doesn't mean you can go out and copy the PDF of the player's handbook and sell it yourself and there's nothing WotC can do. There is a lot of descriptive text in the books, first of all, which is just, creative writing. That's as protectable as any other copyright. And then the whole compilation of rules, as a whole book or as a whole gaming system, is arguably protectable as a, quote unquote compilation. A classic example is one individual phone number is not protectable under copyright. But if you go out and take the trouble of, creating a phone book because you've asked everybody, in town their phone number, that compilation is protected. Similar with maps and things like that. Now, now that we're in the digital world, those examples seem a little antiquated, but the same concept still applies. So if you were to create a gaming system and every single rule was identical to what's found in the player's handbook, you would have a problem. But if you create a gaming system and, some of the rules happen to be more or less the same as what's in the player's handbook, or maybe in, combining different game systems together, typically that's not going to be an issue because on that sort of micro level, individual rules are sort of outside the scope of what could be protected under copyright.
Oh, that's great news because there's a zillion role-playing games out there, and it would be hard if you were going to create an original one, right? And you accidentally have some rule that works the same way as somebody else's, you could get into some trouble, right?
Yeah,
if that was an issue.
Yeah, kind of maybe a better example is recipes, right? Recipes are not protectable under copyright law. So, just because there's only so many ways to do things, and, who's to say that you're the first person to use, a cup of sugar for this or whatever, right? However, if you write a cookbook that has a whole bunch of recipes in it, and it also has narratives about how, your grandmother taught you this recipe, or you went to some great restaurant, you wanted to try to figure out your own twist on it or whatever, if you've ever read a cookbook, you read these little, pieces of creative writing in there, that whole book as a whole is protectable. But if you wanted to go out and say, okay, here's, David's recipe for cookies that I found in his cookbook, you could actually go on your blog and republish the exact recipe, like meaning the measurements and steps and things like that, word for word. And there's not really too much the cookbook author could do about it. And so pretty much the same thing applies in the role-playing game world.
Got it. Okay. And that makes sense because I do see cooking blogs all the time that will kind of word for word repeat a recipe and say, I got it originally from XYZ website, right? Or XYZ cookbook. And I think that makes perfect sense.
Now, I want to be careful about this, though. Just, the more that you're always better putting things in your own words as much as possible. So I'm just kind of giving rules of thumb here and so forth. But even if you are, writing a system or a particular module or whatever that has a specific rule that you've created, and that it's very similar, identical to a rule that you found in some other game system, that's fine. But to the go the extra mile to put things in your own words. Number one, that's going to make your creative output better and more interesting and more valuable. And the more that you do that, just kind of as a best practice, the less likely you are to run into issues with some other company or creator.
Totally. Yeah. I think that makes sense, right? Best practices of if you're going to say you wrote a thing, write the thing, right? So when you're writing your own stuff, it's common, I've found in the role playing game world, that someone will approach me and say, hey, you wrote about this on your blog. I'm writing a setting or an adventure or a rule system or whatever it is. And I'd love to use this. Is that okay with you? And, we'll work out some kind of deal, whether it's, depending on how much of my work they want to actually use. Sometimes it's just credit me, point towards my blog, whatever it is. Sometimes it's, well, that's, you're kind of lifting the whole thing. So let's see if we can work out some sort of financial arrangement or whatever it is. Are there kind of best practices there that we should be aware of on either side, the person approaching and also the person being approached?
Absolutely. Good question. So if you write a blog post, you own the copyright. Just like I said, as soon as you typed it in and hit publish, you own the copyright for that piece of content you've created. And when you own the copyright, that copyright is actually what we call a basket of rights. There's a bunch of different things you can do if you're the copyright holder. One of which is you could sell it. You could just sell it outright, or what we call assign it. So you could sell it to me, and then I own it, and you don't own it. So like TSR created Dungeons and Dragons, but eventually they sold to WotC, and they sold the copyright. You can also create derivative works. Derivative work is any creative work that uses elements from a prior work. So the easiest, an easy way to understand that is like, imagine the very first Batman cartoon or comic book. I don't know exactly what the first. I know there was Detective Comics number 27, but whichever the actual first one that Bob Kane and Bill Finger created, that's, let's say, the original work. And then every single issue after that, every single movie, TV show, whatever that involves Batman is a derivative work of that original. So you can see from that example how creating one creative work can give you potentially an income stream if there's something in there that catches on and becomes popular. So you have the right to create and prevent others from creating derivative works if you own the copyright. Another thing you can do is license all or part of the copyright. So the example, James, that you gave was very much like a license. So, hey, I liked your blog post. I want to use these elements in a game or whatever. Since you're the owner and the creator, you can agree to whatever terms you want. You can license all of it. You can license part of it. You can license it for free or for pay. You can license it for a certain period of time or indefinitely. You can license it exclusively, meaning you're giving them the exclusive right to use it, and nobody else can. Or it could be non-exclusive, and you could, license that to somebody else at the same time. So, it's just like any other kind of contract. The terms can go really in any direction. But yeah, that is one of the rights that you have when you are the copyright owner. So, in terms of, you asked about both sides. So the licensee. So if I'm going to you and I said, hey, I like your blog post, I want to use all of or part of it for this project, I want to make sure that, to the best of my knowledge, that you're actually the owner. I don't want to be paying you or going into business with you if you're not actually, if you just ripped it off from somebody else. That might be handled a lot of different ways. You can kind of do your own due diligence. Okay, I've read your blog before. I know what your writing is like, and obviously this is one of your posts. Or in the contract, I might require you to make a representation stating that you have the right to license this, that you've created it, and that you are indemnifying me, meaning if I get sued because it turns out you're not really the creator, that you're going to pay for the defense and whatever remedy comes out of that. So, just kind of getting into the legalese of that, there's a lot of different ways to protect yourself as the licensee. So, the licensee being, in this case, the person who is asking to use the pre-existing content.
So when we're looking at the Dungeon Masters Guild specifically, have you delved into the legal aspects of the Dungeon Masters Guild?
To an extent, yeah. I'm not a publisher. I only create content for my own table. So I haven't actually used it myself. But I've certainly worked with people who have.
Gotcha. Okay. So what are, sort of from a legal perspective, is there a difference between publishing on the Dungeon Masters Guild and publishing elsewhere like DriveThruRPG or Amazon self-publishing, that kind of thing?
Well, I mean, I guess the Dungeon Masters Guild was really created, my understanding, primarily for Dungeons and Dragons. So you're kind of playing in that sandbox. You are, restricted to an extent because you have to comply with some of the kind of terms or the ways that WotC wants things to be presented. So I'm sure that there are, I haven't looked at the term and conditions of the Dungeon Masters Guild in detail in a long time, but I'm quite sure that there are restrictions. For example, that you can't publish content that might put WotC in a bad light, for example. I'm not saying that, I'm not advocating that, but, from the context of freedom of speech, you may want to publish, let's say, political content or some, use your, use this channel to publish something that, some other person might find offensive or challenging or something like that. And I'm quite sure that there are restrictions around that within the DM's Guild. So that's just kind of one example that comes to mind. But you definitely want to familiarize yourself as best as possible with the terms and conditions so that you know what you can and can't do. Because, just like with a lot of websites, the terms can change over time as well. So you want to keep up on it and just follow, kind of the best practices of that particular channel.
I don't know where you were in your career when the first open gaming license came out with third edition. But I remember, it being like a game changer in the perspective that a lot of people went from publishing their own role-playing games and their own stuff to also becoming third-party publishers who wanted to make things for Dungeons & Dragons because so many people were playing Dungeons & Dragons. They were playing Dungeons & Dragons. It was a great way to have fun and make money in role-playing games. More people would pick up your stuff. It seemed like it was kind of an unprecedented thing. Do you think that's true, that it was unprecedented?
Yeah, well, I mean, I feel like open source is kind of a movement that's been happening for a long time. I think it kind of falls into that. There's been, everything from Wikipedia, which is an open source, encyclopedia project, to, there's just all kinds of things you can find online. So I think in the context of role-playing games or maybe, this type of media, there's an aspect of it that was unique or boundary pushing. There's examples from other contexts that were used. You definitely don't see this with other, let's say, entertainment properties of similar caliber. There's not like you can create your own Marvel comics with Spider-Man, and as long as you follow certain rules, Marvel's cool with it. Cool with you doing that and monetizing it. However, there are a few examples I would think of. So, for example, Disney, Lucasfilm, they kind of do a fan film festival every year, and there you can create your own Star Wars fan film. There are a lot of restrictions about how you do that, but there are specific rules. As long as you're following those rules, you're not going to get in trouble. So that's kind of an example. To my understanding, they're not for-profit enterprises. They're just fan films that are done for fun. So that's not quite the same as the DM's Guild, where you actually can, in theory, make money. Maybe that's kind of a somewhat similar example in terms of a major media property that allows independent creators to come in and play in the sandbox.
From your perspective, what do your clients who work in role-playing games, what are they concerned about a lot when they're coming to you?
They're concerned about, some of the things we've talked about. They're concerned about making sure, that their trademarks are protected and that they can use those brand names that they've created. And they're not going to get in trouble, and that they'll be able to own it and leverage it. Because if you're creating something, you have big dreams. You would love to see your thing become popular and maybe become leveraged in other media. I mean, now we're seeing Critical Role getting signed to do an animated series for Amazon. So certainly a lot of creators out there would like to be why am I not on Netflix? There's no in today's media landscape, there's no real restrictions on where your IP could go. They want to make sure they've got things protected so that they're in that position where if it becomes popular, they can leverage it into other media. Then they have business questions, something like forming a corporation or an LLC. When do you do that? What are the advantages and disadvantages of doing that? How do you go about doing it? I do a lot of those kind of things for clients. Another major thing that comes up is contracts, specifically with other people who are working on a game. So let's say you're developing a game and you're a writer, but you're not an artist. So you may hire an artist or multiple artists to create, art elements for your game or your story. The process of doing that and how that, those contracts work, there's a lot of best practices and things that need to be done right, because you want to make sure that it's clear that you, the game creator, actually owns that content and can do what you want with it. If the contracts are not in place, it doesn't work that way. You're going to have a lot of restrictions and a lot of problems trying to use that content. So that's another thing that comes up. And I guess the third big thing is, or the next big thing, is when you have more than one person working together. So let's say you're not just a solo creator, but you and your partner, or your friend, your spouse, or whoever are working together. To make sure that there are clear documents that state who owns what and how this relationship is going to work. Is it, a 50-50 or an equal split? Who's going to put money into it? Who's going to be responsible for doing what? It could be a very simple partnership agreement all the way to a more complex, corporation with a shareholder agreement and things like that. But on any level, if you're working with somebody on a creative enterprise, whether it's, a rock band, you're creating a role-playing game, a video game, a novel, you name it, get it in writing as early as possible when everybody is happy and when everybody is friends, exactly what the expectations are, who's going to do what happens if money needs to be spent, who makes the decisions, who has the right to, make a decision about selling something or not selling something or entering into an agreement or a partnership or not. If you can't afford a lawyer, I recommend you contact your local bar association. There's a lot of free or inexpensive legal resources available to people who can't, don't have the cash. Local bar association is one way to go. Another way, there's New Media Rights is another organization. They happen to be based here in San Diego, but they do work all over the country. So there's a lot of nonprofits and other ways that you can get legal advice if you need it. But if you can't access any of that stuff, worst case scenario, just put it down on paper. In whatever, phrasing makes sense to you. Hey, we're going into this project together. I'm going to do this. You're going to do that. And here's how it's all going to work. And, it's going to give you an opportunity to really have an important conversation and really get those things cleared up, because you may have something in your head. The other person might have something in their head. And, it's a really good step too, because if you can't put on paper, on one piece of paper, what the expectations are, and who's going to do what the responsibilities are, and how things are going to be split and so forth, that's probably not something you're going to be able to work with. And when something becomes challenging, well, that's a sign that this might be somebody that just is not going to, you're not going to really want to enter in that kind of business relationship with.
That, I think, is really good advice. Definitely from my own experiences, especially starting out, there were so many times where I was like, oh, I wish we had done this. I wish we had, one, talked about it earlier, and two, then I wish we had written it down. And it really does help. And it's funny, it does seem silly sometimes, right? To like, well, we're all friends here. It's going to work out and it'll be fine. But working together is very different than hanging out together. And I think it does help to have those things written down. You are a fan of role playing games. You've been playing them yourself for a while. Is there anything in particular that you like? Is there an IP you wish that there was a role playing game for, or that you wish would maybe there is a role playing game for it, but it hasn't been made since the 90s or that kind of thing? Is there anything that you would love to see rise again, just as a fan?
Yeah, that's a good question. I feel like if I say that, if I come up with something, then somebody's going to come along and say, you idiot, don't you know there's a Casablanca role-playing game or something? Whatever I would say, Citizen Kane, the role-playing game. It's great. Everybody plays it. You haven't heard it. So I'm a little loath to say that. Sometimes I do, when I'm creating, adventures or stories or just reading published adventures. Just because of what I do, I look at and I go like, are there any lawyers in this world? And how are these? Here's the city guard, but who made these laws? And who's determining whether somebody should be punished or whether this villager grazed his cow on the other villager's land or something like the actual things that come up in life. I always wonder, like, would there be a way to incorporate this into a game where you have a little bit of kind of fun legal content without it actually being boring? And I think probably the answer is no. But if I have to come up with an answer of what what role playing game I would like to see, I would say the Dungeons and Lawyers or something like that.
Gotcha. Well, I will work on Ally McBeal, the role-playing game,
okay.
and see what I can get for you. It's interesting, right? There's a series of video games that I'm sure is nothing like Legal Reality, the sort of Phoenix Wright video games. I'm sure you've probably heard of them as a lawyer, and so it does seem like there might be some fun way to dramatize legality, but so much of a lawyer's work happens outside of the courtroom, right? And so many lawyers don't go in, they're not trial lawyers. They don't go into a courtroom in the sense that we see them, in television or movies or that kind of thing. But it is fascinating to me. I love talking about this stuff, and I love talking to lawyers of all stripes. So one who is in Dungeons and Dragons and is interested in copyright and trademark law is just right up my alley. So thank you so much for coming on. I really appreciate it. Before we go, is there anything in particular that we haven't touched on that you want people to know?
No, I think we covered a lot of this. I really enjoy educating, creators and people just interested in the arts about the law and their rights and what they, should and shouldn't do and things like that. I think that, as somebody who works in that space, it's important to make sure that people really do know this stuff. I have a blog on my website that, I have hundreds of articles about these things. Some of them relate specifically to Dungeons & Dragons, and others are just all kinds of other media or creative business type stuff. So I would direct people there. And, of course, if you have questions, I can't answer people's specific legal questions, like a particular problem that they're having. But if there are general questions that could apply to creators or people in the role-playing game business in general, I love hearing those things because they can generate ideas for blog posts and other content that I'm putting out. So I would definitely encourage people to go there and check that stuff out. My name is David Lizerbram, and so there's only one of me. So if you search for David Lizerbram and get the name even somewhat close, Google will find me. And my website is lizerbramlaw.com. So again, even if you can't spell it perfectly, it's as long as you get close, you'll find me. So I hope people listen to this, and my number one hope is that somebody listens and goes, oh, but what about this? And then it's another interesting topic that I could write about or educate people about down the road.
Gotcha. Well, thank you. It's just really great to talk with you about this, and good luck with the games and everything else. So thank you for coming on Tabletop Babble today.
Thanks. Hey, can I throw one more idea out there? I just
absolutely
kind of occurred to me. If there are any lawyers who listen to the show, which I'm sure there are, because there are plenty of closet role-playing lawyers. I have the idea of starting a role-playing game lawyers bar association, meaning people who are in this space, we can all communicate, share ideas, and things like that. So if there's any lawyers out there, hit me up. Might be something fun to do.
Well, thank you so much. I really appreciate it, man. And I think that we will be talking to you again soon. I'd love to know more about your games and things like that, David.
Thanks a lot. It was a lot of fun.
That was a great interview. If you enjoy Tabletop Babble, why don't you give us just $1 a month? It would be a huge, huge help. You probably wouldn't even notice it whisking right out of your bank account, and you would support the show that you love. Just $1 a month makes such a difference. You have no idea. This show has a lot of costs that we need to cover to get it made on time to you every single week. So, how can you help us out? Head on over to patreon.com/Intricasso. That's patreon.com/Intricasso, where you can check out all of the awesome rewards. But honestly, the biggest reward is that you help make this show a reality, something that I hope you appreciate and love. For $1 a month, we're talking 25 cents or less an episode. So go, please, please, please help us out if you can. And let us know that you love the show. If you're already giving through Patreon, I super, super appreciate it. And hey, if you want to help us out for free, maybe you can't contribute to the Patreon, I totally understand. Maybe you already are and want to do something extra. I totally understand that too. Head on over to iTunes, leave us a 5-star review. If you're listening in Apple Podcasts right now, guess what? In the app that you're listening to me talk in, you can click over right now and leave us a 5-star review. It takes 30 seconds of your time, whether you're at your computer or on your phone, whatever it may be. It helps other people find the show. And if you leave us a 5-star review, I will read it out loud on the show. You can make me say anything you want. It's been pretty fun. I'm looking for people to get creative with this. So go nuts. All right, people, you can find me on Twitter at James Introcaso. That's at JamesIntrocaso, and also worldbuilderblog.com. Tabletop Babble is a show on the Don't Split the Podcast Network. Thanks to Rudy Basso for founding it with me. Our theme music, which you're listening to right now, was provided by Battle Bards. Don't forget, RPGs are like sex. Hey everybody, thanks for listening to this episode of Tabletop Babble, which was brought to you by Hero Forge. Now, Hero Forge make incredible custom miniatures. They have all kinds of race options that are constantly being added to and updated, and all of the little features that you can put on, hundreds of customizable options. I'm talking about poses, weapons, facial expressions, hair, facial hair, hats, clothing, all kinds of awesome stuff. I use Hero Forge all the time. I love to go on there and build minis, and you can get them shipped to you in a variety of materials, including plastic and metal options. Hero Forge also offers downloadable model files for use in 3D printers. So if you got a 3D printer, guess what? You can print your own design by going to the Hero Forge website. Hero Forge is constantly expanding. So those options that I was talking about, there's always more and more and more. There's new parts every week, and major features like races and custom posing are constantly available on a regular basis. So guess what? You're really going to want to check out Hero Forge, because this holiday season, you can surprise the gamers in your life with a Hero Forge gift card. These cards are delivered instantly via email and can be used to purchase all minis on the site, digital and physical. You can click on the link in the comments for this episode to grab your gift card today. So go check it out at heroforge.com.